Thanks for joining us this evening. My name is Ewan Watt. I'm the Manager of External Affairs with the Charles Koch Institute. As the more than 1,000 alumni of our organization's educational programs can tell you, the Charles Koch Institute welcomes debate, scholarship, and analysis of crucial public policy issues. The role of the judiciary, specifically how it rules on property rights and occupational licensing, forms an important part of our curriculum on economic freedom. Writing the majority opinion in New State Ice versus Oklahoma, Associate Justice George Sutherland stated, "In Near v. Minnesota, the theory of experimentation and censorship was not permitted to interfere with the fundamental doctrine of the freedom of the press. The opportunity to apply one's labor and skill in an ordinary occupation with proper regard for all reasonable regulations is no less entitled to protection." Sutherland held that all constitutional liberties, be they economic or expressive, be protected on an equal basis. It's been noted that Sutherland's argument won the day 80 years ago, but has since been abandoned. Our special guest this evening claims that the modern court has taken a different path from Sutherland, treating liberties as either fundamental or non-fundamental. In his new book, Terms of Engagement, he argues that the judiciary's knee-jerk deference to the other branches has resulted in an explosion in the size, cost, and intrusiveness of government. In his work, he states that rather than confront the alleged danger of judicial activism, we should be focused on justices abdicating their responsibility, as James Madison put it, to serve as an impenetrable bulwark against every assumption of power in the legislature or executive. As part of the Charles Koch Institute's work to foster productive dialogue among diverse voices on critical topics, we are pleased to welcome this evening the Director of the Institute for Justice's Center for Judicial Engagement, Clark M. Neily.
Thank you. Thanks. I guess the mic's working. Drop that down a little bit. Well, thank you so much for having me here, and thanks for the opportunity to talk to you about this, I think, the most important subject that there is, and that's limited government. That's really what the book is about. And if I had to distill it right down to its essence, what I would say is this. We have a constitution that provides for about this much government, but we actually have, well, my arms aren't stretchy enough, but we have a lot of government. And I've been a litigator at the Institute for Justice for 13 and a half years, and during much of that time, I found myself thinking, like, how is it that we have such a wonderful constitution? I really believe that it's the greatest secular document ever written. It is a work of genius. And the genius of the Constitution is limited government. How do we have such a genius Constitution that speaks so clearly, at least to my mind, about the limits of government? And yet, when you look around, we have this enormous behemoth. And it's not just the federal government. It's government at every level, federal, state, and local. Spends more money than it takes in. It puts its nose into every little bit of our business. It regulates all kinds of ridiculous things. And I find that impossible to reconcile with my understanding of the Constitution and its commitment to limited government. And so the more I reflected on this, the more I formed the conviction that it's actually pretty simple. And the reason why there's such a disconnect between the Constitution's limits on government and the out-of-control government we have is that the judiciary is mailing it in. There is an epidemic of fake judging in this country. The Supreme Court has essentially held that only in some constitutional cases should judges make a sincere, meaningful effort to enforce constitutional limits on government power, and in the vast majority of cases, they should simply rationalize backwards from a predetermined outcome, which is that the government is going to be permitted to do whatever it wants. And the book is essentially an attempt to show that that's true, not just assert it, not just argue it, but to document and illustrate that that is the truth. That in most areas of constitutional law, the courts are simply mailing it in, not making any kind of of a sincere effort to enforce constitutional limits on government power, and that has led to a tremendous loss of liberty in this country. So what I thought I'd do is essentially use some of the illustrations in the book to try to show you, hopefully fairly quickly, that this isn't just sort of a disgruntled libertarian constitutional litigator talking, although I may in fact be a disgruntled libertarian constitutional litigator, but I actually think that this charge of judicial abdication can, and in my judgment in the book, has been substantiated. So let's talk about a couple of different areas in which the courts are not making a sincere effort to enforce constitutional limits on government power. One that's presumably very much on people's minds is the issue of federalism. For those of you who don't know, the Constitution created the federal government. We didn't have one before the Constitution was ratified in 1788, went into effect in 1789. Up until that point, we didn't have a federal government. And the idea of creating one provoked tremendous anxiety, concern, and resistance among many people in this country. And the problem, basically, was that we had just spent 8 years fighting off the world's greatest imperial power, Great Britain. And people felt that if we created a federal government, as was proposed in the Constitution, that government might tyrannize us, just as the British had. And so there was great reluctance to essentially ratify a document that would create this brand new, potentially tyrannical government. And this provoked or kicked off one of the greatest political debates in human history between the Federalists, who advocated the ratification of the Constitution, and the Anti-Federalists, who resisted it. And as that debate unfolded, what became clear is that whether or not people were going to agree to support the ratification of the Constitution was going to come down to one issue, and that was whether the people would be sufficiently assured that the powers of the federal government would be so limited that it could never tyrannize the people. And that promise was made. In fact, James Madison in the Federalists specifically stated that the powers of the federal government would be few and defined. How did they achieve that? Well, they achieved that by enumerating the powers of the federal government, by listing them specifically. I use the illustration in the book that it's analogous to protecting yourself from a shark if you're in the ocean. You can go into the shark cage yourself, in which case you just have a few inches of room to swim around, or you can put the shark in a cage, in which case the rest of the ocean is yours. They chose the latter approach. They essentially said, okay, we're going to take this powerful and potentially dangerous federal government, and we're going to limit its power by only delegating to it a handful of powers, things like punishing pirates and counterfeiters, and not much beyond that. But as you know, and government being what it is, government constantly pushes at the bounds of its own power. Both branches, the legislature and the executive, constantly pushing to exercise powers that are not granted to it in the Constitution. And up until about the late 1930s, early 1940s, the Supreme Court actually held the line pretty well and essentially said, you know, really you can only exercise those powers that are delegated to you in the Constitution, and there are not that many. Unfortunately, during the New Deal, a group of people had a different vision for the United States, and they felt that in order for the United States to recover from the Great Depression, it was necessary to give the federal government the power to manage the United States economy from the top down. And they initially ran into an obstacle with the Supreme Court. The Supreme Court struck down a number of federal laws that had that object. And then for a variety of reasons, the Supreme Court caved and essentially said, we are no longer going to be in the business of imposing or enforcing any meaningful limits, or at least any meaningful delegated powers-based limits, or you might think of them as 10th Amendment-based limits on the federal government. And we were reminded of that, of course, just 1 year ago when the Supreme Court considered the constitutionality of the Affordable Care Act, otherwise known as Obamacare. My friend Karen Harnett in the audience here helped lead the charge. She's general counsel for NFIB, which was the plaintiff in the case. And as I'm sure you know, when that case got to the U.S. Supreme Court, by one vote, the U.S. Supreme Court said that that was a constitutional exercise of federal power. What was effectively the federal government takeover of about 1/6 of the United States economy. It was the greatest exercise of federal power since the New Deal, and in my judgment, one of the most blatantly unconstitutional. And by one vote, the U.S. Supreme Court said, that's fine. There was an interesting twist in the case because, as I suspect many of you know, when the federal government wants to exercise powers not constitutionally delegated to it, it generally invokes the so-called Commerce Clause, the power to regulate commerce between the states, or as I refer to it in the book, old reliable. And for 75 years, it has been reliable in every single case except for 3. There was the Gun-Free School Zones Act was struck down on Commerce Clause grounds in 1995. There was a portion of the Violence Against Women Act that was struck down on Commerce Clause grounds in 2000. And then in the Obamacare decision, 5 justices actually said that that is not a valid, that requiring people to purchase government-approved health insurance is not a valid exercise of the commerce power. But then Chief Justice Roberts rewrote portions of the Affordable Care Act to change the penalty that is imposed on people who don't get government-approved health insurance into a tax. He said basically that even though the statute says it's a penalty, and even though it's called the individual mandate, not the individual option, it's actually just an option. You can get government-approved health insurance if you want, but you don't have to. And if you choose not to, then you're just going to pay somewhat more in taxes than other people. This is a preposterous reading of the statute. It is not a faithful reading of the statute. That's not what the statute says. And the penalty, and that's what it is, that's what the law calls it, the penalty that is imposed upon people for not purchasing government-approved health insurance is not remotely a revenue-raising penalty. It was not designed to, in fact, to the contrary, it was designed not to raise revenue because they wanted everybody to get on board. And so this is a preposterous reading of the Affordable Care Act, and the public was sold a bill of goods, in my judgment, by the Supreme Court, which, as it usually does, bent over backwards to try to find a way to rationalize what the government had done. Now, those of us who are conservatives and libertarians, or just supporters of limited government, were told that we were supposed to see in the opinion a silver lining, that there was something to be happy about because 5 of the justices had laid down a marker on the commerce power and essentially said, well, you know, this is too far. This is a bridge too far with old reliable. We're not going to uphold the exercise of commerce power. As a litigator, I'm not all that interested in what courts say. I'm much more interested in what courts do, because that's more important. Judges, you know, talk is cheap, and it really is, especially in a judicial opinion. What counts is the holding of the case and what the government was or was not allowed to do. So the idea that the Supreme Court laid down a marker on the commerce power, if that's true, the lower courts didn't get the memo. And let me give you an example. Just 5 months after the Obamacare decision came down, the 11th Circuit Court of Appeals, which covers Florida, Alabama, and Mississippi, handed down a commerce decision. And this is important because, keep in mind, the 11th Circuit was the only circuit court, the only federal appeals court that held that Obamacare was unconstitutional, that the individual mandate was unconstitutional. So they did not buy either the commerce argument or the taxing argument the first time around. But then after the Obamacare decision came down, the 11th Circuit had a really whimsically funny commerce case. Has anybody ever been to Key West, Florida? My wife and I were just there in February. Okay. So Ernest Hemingway used to live there, and he did some of his best writing in a house there. And they've transformed the house into a museum. It's called the Hemingway Home and Museum. And if you go there, what you'll see is that it is there are cats all over the place. There's about 35 or 40 cats on the grounds of the museum. And they are the descendants of a cat that Hemingway was supposedly given as a gift. And the name of the cat was Snowball. I think that's the name of the Simpsons cat. It doesn't really matter. But and it had 6 toes. It was a polydactyl cat. So there's like 35 or 40 6-toed cats running around the Hemingway Home and Museum. And apparently the museum had a falling out with one of their volunteers. And they did something that annoyed her, and so she decided she was going to get back at the museum. And the way she was going to do it was she was going to get them in trouble for not taking care of these cats properly. See, the cats were allowed to sleep outside. If you've ever been to Key West, people sleep outside in Key West. It's not a big deal. It's also the southernmost point in the United States. It's not particularly cold, and there's no problem with cats sleeping outside, but she decided she would try to get them in trouble. Now, who do you suppose that she went to in order to get the museum in trouble for the way it takes care of cats? You might think the local animal control folks. You might think the county health board. Nope. She went to the U.S. Department of Agriculture, the federal government, and ratted out the museum to them. Now, those of us who actually think that James Madison was serious about the idea that the Constitution created a power, or a federal government of limited powers, your ears might prick up and say, now, is there anything in the Constitution about pet care? I didn't see that in Article 1, Section 8. And so actually the museum challenged the department. Oh, I should add this, by the way. So the Department of Agriculture actually opened a 2-year investigation to document what no one disputed, and that is that, in fact, the cats were sleeping outside on the grounds of the Hemingway Home and Museum. And they invoked a law that was put on the books in the 1960s that covers exhibitors of animals. The law was initially enacted to enable the federal government to go after circuses that abused elephants. You know, these circuses are constantly moving all over the country, and so the federal government needed to be able to regulate the treatment of elephants. It was also construed to apply to, for example, laboratory chimps, that kind of thing. But the step from elephants and chimps to cats is a big one. And the question was whether the Department of Agriculture had the constitutional authority to dictate to the Hemingway Home and Museum how to take care of their cats. And a couple things about these cats that one would have thought was noteworthy. They've never been bought or sold. They just got born. And they're descendants of a cat that's lived there since the 1930s, or they first lived there in the 1930s. And the second thing about them is they're marooned on an island, the very southern tip of Florida. They're never going to cross the state line. So how is it that these cats could have a substantial effect on interstate commerce? Because that's the standard. But again, we're talking about old reliable here, and we're talking about judicial abdication, and we're talking about not actually deciding constitutional cases on the basis of any sort of faithful interpretation of the document. We're just talking about fiction. We're talking about creative writing. We're talking about bending over backwards to say yes to government. That's what the federal judiciary is all about these days. So how does the 11th Circuit get there? Well, guess what? They got a gift shop. And in that gift shop, they sell cat-themed merchandise. And so the theory was, well, maybe people are coming all the way down from New York and Virginia and over from Texas, where I was this morning, to buy themselves a nice cat pot holder or a cat keychain. And that's the substantial effect on interstate commerce. That's ridiculous. I mean, it is what they said, but it is also ridiculous. That is not remotely a faithful attempt to enforce the Constitution, and it breaks faith with the promise that was made to the people of this country that the federal government would be one of few and defined powers. Now, you can argue back and forth about whether that decision was or was not consistent with U.S. Supreme Court precedent and U.S. Supreme Court doctrine, and I don't dispute that the lower courts are obligated to apply that to the best of their ability. But I want to go to the essence of the matter and just say this. When you have a federal court holding that the federal government can dictate to a museum in Key West, Florida, how to take care of a bunch of cats, something has gone terribly, terribly wrong with the idea of limited government. And in fact, it has. And in fact, the promise that was made, the basis of the constitutional bargain that I described a moment ago, namely that we would have a federal government of truly limited, enumerated powers, the government broke faith. The courts broke faith with that promise. Now, they did it a long time ago, but they keep doing it. Some of you in the audience may be familiar with the Raich case that came down, I think it was in 2005. This is a case about whether if you grow a plant in your backyard and then give it to somebody who lives next door to you, is that interstate commerce? You didn't sell it, right? And it didn't cross a state line, but can the federal government regulate that as an exercise of its interstate commerce power? Yep, it can. And of course, the plant was marijuana. So once you know it's drugs, it doesn't really matter what the Constitution says because, darn it, Congress wants to regulate drugs. And so, of course, the Supreme Court is going to get on board and just reason backwards from the predetermined outcome, which is Congress gets to do what it wants. And then the rest is just details. The rest is just creative writing, as I suggested a moment ago. Unfortunately, it's not just federalism. The Supreme Court's abdication of its responsibility to enforce constitutional limits on government power extends into almost every area of your life. And let me just give you a few examples. I was part of the trial team in the Kelo case. Kelo was the case in which the U.S. Supreme Court upheld the use of eminent domain for so-called economic development. Basically what happened was the city of New London, Connecticut decided that they wanted to bulldoze an entire working-class neighborhood called Fort Trumbull. And it was actually really well located. It was beautiful. It's a beautiful location. Fort Trumbull is located right where the Thames River goes out into Long Island Sound. But it was a working-class neighborhood, and there was a Pfizer facility right next door. And essentially what happened was a local busybody named Claire Gaudiani, who ran the New London Development Corporation and was also president of Connecticut College, whose husband happened to be a Pfizer executive, got together with some other Pfizer executives and essentially said, hey, what would you think about if we built you Yuppieville right next door in Fort Trumbull? And they said, well, we'd like that a lot. That would be great. And she said, well, good, then we'll just scrape the neighborhood clean and build you Yuppieville. And the problem was not everybody wanted to leave. In fact, Suzette Kelo didn't want to leave. She lived in this beautiful pink house that she had completely refurbished and actually gone to the library to research what color that house would have looked like when it was built in the late 19th century. It turned out to be pink, surprisingly, but that's what she did. And that case basically became a juggernaut. That case became, I think, for what for many Americans, it became sort of the living example of judicial abdication, because when it got up to the US Supreme Court, it was a very simple, very straightforward question. The Fifth Amendment says that private property may not be taken for public use except with just compensation. That's always been understood to impose two distinct limits on the use of eminent domain. First, it has to be for a truly public use, and second, there has to be just compensation. So how is there a public use when the government takes somebody's home or business and then just gives the property to another private, in this case it was a private property developer, to just make nicer houses and to build a 4-star hotel? How in the world is that a public use? Well, the Supreme Court didn't actually find that it was a public use. It found that it was a public purpose, because maybe that would create some jobs and maybe it would increase the tax base. And the fact that the Constitution says public use, not public purpose, shouldn't slow us down at all. Just a little bit of a stretch. And upheld the taking on the hope on the part of a bunch of, frankly, yokels on the New London City Council that this project would result in this flourishing of the economy of New London. It didn't. The only jobs created by that project were for the bulldozer operators who bulldozed the neighborhood. If you go up to Fort Trumbull today in New London, what you're going to see is a 90-acre brownfield. So what happened basically was the New London Development Corporation was allowed to play real estate developer with about $88 million in taxpayer money. They blew it all on a project that involved the violation of about 24 people's constitutional rights, and they got nothing for it. And that happens a lot. We've documented that in a study. The Institute for Justice has documented that in a study called Redevelopment Recs. But the part I want to focus on is that the US Supreme Court upheld this. The US Supreme Court said that this is fine. Let me share with you a story that I think is quite striking and for me puts this in a stark context. When the decision came down in June of 2005, a couple months later, I went out on the road to debate whether Kelo was rightly decided or not. And the first place I went, actually, was my alma mater, the University of Texas Law School. I went there to debate a property professor. And it just so happened, I had worked in Dallas before I came to the Institute for Justice. It just so happened that two partners from my firm were there recruiting law students, and I went up to say hello. One of them was an intellectual property partner, and he had just come back from China. And he said, I have a story to share with you that you might find interesting. It relates to the case that you're talking about. He was in China in May, so this was about 6 weeks before Kelo came down. In May of 2005 is when he was in China. And he was there to do a deal to create a computer chip factory, to build a silicon chip factory. And his host said, would you like to see where it's going to be? And he said, yeah, sure, let's go. And so the guy drove him out in the countryside. They go up over this hill, stop the car, get out, look down, and his host says, right there, and there's a village down at the bottom of the hill, and he says, that's where the factory is going to be. And the lawyer from Texas, his name was Steve, Steve looks down and he says, well, how can we put a factory? There's a village there. And his host, his Chinese host, says, oh, the government will make him leave. And Steve, without even thinking about it, said, oh, you can't do that in my country. 6 weeks later, he found out he was wrong. 6 weeks later, he found out that when it comes to property rights, there's not a shred of difference between the United States and mainland China when it comes to the use of eminent domain. I hope you find that sobering. I find that dismaying. And by one vote, the US Supreme Court essentially just threw property rights completely off. I mean, it had been hanging on by its fingernails onto the back of the constitutional sled. And in Kelo, the Supreme Court just finally pried off the last few fingers and threw property rights completely off the back of the constitutional sled. And I think that's dismaying. Let me give you another example. One of the things that's important to realize here, and let me just do about 30 seconds of constitutional law for those who haven't had it. The US Supreme Court divides your constitutional rights into two categories, as you had mentioned before, fundamental and non-fundamental. Those are euphemisms. That's just fancy judge speak. What they really mean is meaningful and meaningless. You have meaningful rights, like the right of free speech, the right of free exercise of religion, a couple of more, and you have meaningless rights, which is everything else. And the difference between a meaningful and a meaningless right is a meaningful right is one you can go into court and actually have a decent chance of vindicating, because you'll be in front of a judge who actually acts like a judge. They will try to determine what's really going on the basis of evidence and truth, and it's a truth-seeking process, and they will be completely neutral. When you go into court to try to defend a meaningless right, which is what I mostly do, things like running a business or working in the occupation of your choice or not being thrown out of your home by a creep like Claire Gaudiani so they can bulldoze it and give it to a property developer, those are meaningless rights. Your right to own property, earn a living, so forth, those are meaningless rights according to the Supreme Court. And as meaningless rights, they don't receive any meaningful judicial protection. Instead, they get something called the rational basis test, which is a giant constitutional fraud. And it's the default setting in constitutional cases. The exception is for the court to apply genuine judicial review, the default setting is to apply the rational basis test, which, as I said before, is a fraud. When you go into court to try to protect a right under rational basis review, instead of a neutral adjudicator, basically what you get is another advocate working for the government, and that advocate happens to be wearing a robe. And I say that advisedly because here's what happens. When you try to get a law struck down under rational basis review, as the person challenging the law, you actually have to negate every conceivable justification for the law, even purely imaginary ones, even completely insincere, untruthful, factually unsupported ones. You have to negate everything. And here's the really crazy part. If the government lawyer is insufficiently creative to make up a justification for the law, the judge actually has to get involved. The judge is charged with helping the government win that case by dreaming up possible justifications for the law. And evidence doesn't matter. The government is not required to support any of its factual assertions with evidence. And if you are basically, if the judge can come up with any sort of imaginary justification for the law, then you lose. And let me give you a very personal illustration of that. This is the most difficult case that I've ever worked on because, well, you're going to see. It was a very emotional case for me. Louisiana is the only state in the country where you have to have a license to be a florist, just like a doctor or a lawyer has to have a license to do their job. And I represented 3 women. The lead plaintiff was a woman named Sandy Meadows. Sandy was a high school dropout from Mississippi and a widow. And she had no vocational skills except for one, and that was making flower arrangements. She was good at it. She was actually good enough that she managed the floral department of an Albertsons grocery store. And she had tried to pass the test, but the test to get the license in Louisiana was rigged, and I say that advisedly. You actually had to do 4 different floral arrangements in 4 hours, and then those were judged, not by some theoretically disinterested bureaucrat. They were judged actually by a panel of working florists that would be brought in to decide whether your work was good enough that you should get a license so you could go out and compete with them. Not surprisingly, they usually said no. We got the data, and the pass rate on the Louisiana florist exam for the past 10 years at the time we challenged it was 36%. By way of comparison, the pass rate on the Louisiana bar exam was 61.5%. It was actually about twice as difficult to be a florist in Louisiana as it was to be a lawyer. And but, you know, it's a meaningless right, the right to earn a living, the right to put food on your table. It's a meaningless right. So the government got to defend it under rational basis review, and they got to come into court and just make stuff up. It didn't matter if it was completely insincere and untruthful. They're invited to do that. In fact, they're rewarded for doing that because you get the law upheld if you're creative enough. And one of the state's arguments was that the law was maybe enacted to protect people from the physical dangers of unlicensed floristry. And those, of course, include things like errant corsage pins, infected dirt. And then my favorite one was I actually deposed a guy from the Louisiana Horticulture Commission, or the Floral Police, as I came to call them. And he said, well, you know, maybe one of the reasons for the law is that if you look at a bridal bouquet, those are the stems of the flowers are actually held together with something called floral wire, and then that's covered with tape. So if that's not done properly, maybe that whole arrangement could just come unsprung as the bride turns from the altar to walk down the aisle, and then she could get all tripped up in that floral wire and do a faceplant on her wedding day. So maybe that's what's going on. Well, this is ludicrous. I mean, this is obviously ludicrous, but that's okay. It's okay to be ludicrous if you're the government in a rational basis case, because again, you're rewarded for just making stuff up. And in this case, the law was upheld by a federal judge who did uphold it partly on the basis of infected dirt, and I still don't know what it was infected with, and he didn't seem to mind the fact that there was absolutely no training about infected dirt, nothing on the test about infected dirt, but somehow he made the connection. And so it was, you know, the whole thing was sort of surreal, and it's funny in some ways, but the ending is not funny, I'm afraid. Sandy Meadows was working under the radar screen. She didn't have a license to be a florist, and so when the Horticulture Commission found out about that, they came to that Albertsons grocery store and they said, you have to get rid of her because she can't run this floral department when she doesn't have a license. And so they had no choice, so they fired her. And she had no job, and she died about 3 months later, unemployed, alone, in poverty, because the state of Louisiana wouldn't allow her to do the one thing she could do for a living, and federal courts stood by and did nothing. And you can probably tell from my voice that I find that very sad, but I also find that very outrageous. And it's part of the reason why I decided I wanted to write this book. I wanted to share that experience with people and make sure that people understand it's not just about you know, the Department of Agriculture doing ridiculous things with cats in Florida. It's not just about the federal government you know, trying to nationalize 1/6 of the economy in healthcare. That's bad enough. But it gets right down to the individual level. It gets right down to people's houses being bulldozed for ridiculous land speculation schemes that are not going to come to anything. And it comes right down to a widowed woman from Mississippi with no job skills who's not permitted to do the one thing she can to support herself and dies as a result. This has to change. We can't continue to be the United States of America with a judiciary that refuses to enforce the Constitution consistent with its text, purpose, and history. We deserve better, and Sandy Meadows most assuredly deserve better. Thank you. It looks like there's a mic, so if anybody wants to throw pies or ask questions, feel free.
Should I stand? My name is Ryan Mulvey. So my question is more about federal judges protecting the rights of individuals against state governments. I think the federal government, you have Article 1, Section 8, you have the Bill of Rights. That's easy enough.
Right.
But state governments, what would be your theory for how a federal judge should understand the vague terms in the Constitution when it comes to like the 14th Amendment?
So great question. I appreciate the question. And this is certainly a concern that a lot of people have. What is it in the Constitution that empowers the federal judiciary to protect individuals from state regulations? And it is the 14th Amendment. The 14th Amendment has three substantive provisions: the Privileges or Immunities Clause, the Due Process Clause, and the Equal Protection Clause. I don't have time to give you a full, sort of explication. I'm happy to talk to you afterwards about it. But in a nutshell, what I would say is this. The history here is that in the wake of the Civil War, many states, particularly southern states, basically tried to keep newly freed black people in a state of constructive servitude. So they denied them civil rights across the board. Everything from the right to speak, to the right to travel in search of better opportunities, even the right to own a gun. They specifically took weapons away from newly freed slaves to make them easier to lynch. And that is an incredibly ugly part of our history. But that actually is the genesis of gun control laws in this country. They started in the South in order to disarm newly freed blacks and their white supporters, to make them easier to terrorize and to lynch. And this was so outrageous to the people of this country, particularly Reconstruction Republicans in Congress, that they first passed a number of federal laws to empower the federal courts to prevent this from happening. And when the constitutionality of those laws was called into question, they proposed and ultimately ratified the 14th Amendment in 1868. There was not the slightest doubt what the purpose of the 14th Amendment was, and it was to put an end to that kind of tyranny by empowering the federal courts to protect the individual rights of every American citizen, white, black, and every other race. That's where the power, that's where the federal courts get the power to declare unconstitutional state laws that interfere with people's liberty. Other questions? Yeah.
Hi, my name's Lawrence Kogan.
Hi.
Did you cite in your book another example such as judicial deference to federal agency decision-making under Chevron, which seems to have gotten a bit out of control?
Yeah, great question. I appreciate it. So I don't really get into that a whole lot, but it is an incredibly important issue. Essentially, what has happened is that Congress is so interested in regulating so many things that what it has essentially done is created a fourth branch of government, which is the administrative state, and then delegated to federal agencies. I mean, there's a whole alphabet. It's kind of hilarious. I think I looked online one time and tried to see if anybody was able to count all the federal agencies. I'm not sure anybody's ever been able to do that. But there's federal agencies that are in control of all, just things that you couldn't even imagine that the federal government would be interested in. They're in control of. And as the premise of the question suggests, there's no real oversight here. There's certainly no congressional oversight of any significant kind. And the courts have largely abdicated any responsibility to meaningfully review the regulations that are produced by these agencies. They invented this thing called Chevron deference, which essentially says, I'm sure you guys are doing fine, and maybe we'll get involved in some hypothetical case that we haven't really seen yet. I mean, that's sort of true. But basically, this legislatively invented fourth branch of government is not subject to any meaningful review or control by the courts, and that is a disgrace. Yeah, do you want to follow up? Yeah. Yeah, I think it does. I mean, it has been proposed that regulations that have a certain monetary impact, I don't know what, Karen, I don't know if you know what the cutoff, someone's proposing like 10 or 100 million, I don't know. 100 million, that if an agency proposes a regulation that could have $100 million or more in financial impact, then it has to go back to Congress to get specifically approved. And that's fine. I suppose that would be a step in the right direction, but it doesn't really get us where we really need to be going, which is to begin the dismantling of this constitutionally illegitimate fourth branch of government. I'll take your word for it. Yeah, Karen?
Yeah, I have one as we're on the subject.
Yeah.
So I've actually talked to a practicing attorney who seems to think that you're going to start seeing, or we're starting to see, more pushback at the circuit courts on some of the regulatory overreach. But I have not seen this. I was just curious, do you have any examples of judges doing their duty when it comes to the, curbing the administrative state?
Nothing comes to my mind. Yes? Okay. 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 So it sounds like maybe there's a bit, although sort of. Oh, okay, gotcha. All right. So affirming that there does not appear to be a great deal of activity when it comes to pushing back on agencies. Yeah. Okay. Fair enough. Anybody else? Yes, sir. Yeah.
Hi, I'm not a lawyer, but it appears to me that an awful lot of the Congress and certainly the administration is just ignoring the law just as much as the Supreme Court is, or the rest of the courts for that matter.
Right.
So it appears to me that the whole country is allowing the government to just run rampant.
I would agree with that, but I would add that the framers didn't expect the other branches to obey the Constitution. They might have hoped that they would, but they certainly didn't expect it. And that's why they created the third branch of government, the judiciary, and specifically charged it with the obligation to enforce constitutional limits on government power. So when I see Congress ignoring the Constitution, as it has been doing for the last 75 years, I am disappointed but not surprised. And I don't think the framers would have been surprised either. When I see the courts ignoring the Constitution and allowing the other branches to get away with demonstrably unconstitutional behavior, then I am both disappointed, surprised, and angry. Because, Congress, at least theoretically, we would want Congress to obey and respect constitutional limits on its own power, but that's just not going to happen. I mean, we can hypothesize a magic pony that could fly in every once in a while and persuade congressmen to obey the Constitution, but that's ludicrous. And so is the idea that they'll do it voluntarily, with or without a magic pony. What we do need is a properly engaged judiciary that says, look, the basis of the constitutional bargain in this country was a federal government of few and defined powers, and you haven't been a federal government of few and defined powers for more than 8 decades. And I lay that responsibility at the feet of the judiciary. I really do. I don't think it's anybody else's responsibility to ensure constitutional compliance but theirs. We can certainly hope that other members of other branches take more seriously their obligation to obey the Constitution, but that's just hope. The duty lies with the judiciary, and they are systematically shirking that duty and have been for some time. Thank you. Good question. Yeah.
Hi, I'm Harry Painter. My question is, to what extent do you think a solution might involve the state stepping in, as Thomas Jefferson advocated, and nullifying unconstitutional federal laws?
Not much, I'm afraid. They don't have the power to do that. There's a supremacy clause in the Constitution. States can refuse to help enforce federal laws for whatever reason, because they don't like the policy or because they judge it to be unconstitutional. But states can't abrogate federal laws. They just don't have the power to do that. Now, they can agitate. They can do symbolic things like a number of states have done, passing the "we're not going to enforce gun laws" law or something like that. But they don't really have any substantive effect. So an example that's very much in the news is a number of states, as you know, have legalized marijuana, whether for medicinal purposes or just any purpose. But it remains the case in those states that the federal law against the possession and distribution of marijuana remains in effect, and you are subject to federal prosecution, even in California, for example, or Colorado, where marijuana is legal across the board. There's nothing that Colorado can do other than refuse to participate in the enforcement of that federal law, but there's nothing that Colorado or California can do to stop the federal prosecution of people in those states. So it's disappointing, but it's a fact of our federal system. Yeah.
Hi, Jared Meyer with the Manhattan Institute. I was just wondering how you bring a law from the meaningless back to meaningful, and if there's any precedent of this, and which rights you think are on the way to becoming like that?
Great question. I appreciate it. It has happened. Hopefully this will shock you and scare you a little bit. But the one right that got moved basically from the meaningless category to the meaningful category is the right not to be sterilized for eugenic purposes. We did quite a bit of that in this country in the 20th century. In fact, about 60,000 people, mostly minority women, were sterilized for avowedly eugenic purposes. And the first time that got up to the U.S. Supreme Court in a case called Buck v. Bell in 1927, the Supreme Court said that's just fine. And in fact, it provoked one of the most memorable lines in Supreme Court history. The estimable Oliver Wendell Holmes Jr., a champion of judicial restraint, a truly modest, if that's the word, Supreme Court justice, said that 3 generations of imbeciles are enough, and therefore the state of Virginia should be permitted to sterilize a 19-year-old woman named Carrie Buck. Carrie Buck, by the way, was said by the state of Virginia to be both dim-witted and promiscuous. Both of those statements were false. She was not of subpar intelligence, and she did have a baby out of wedlock. It was because she got raped by a family friend. But nobody really cared about that, and when you have a judiciary that's completely checked out, then there's not going to be any safety net, not going to be anybody to actually protect someone who is, for example, sterilized on the basis of a fraud, as Carrie Buck unfortunately was, and she was sterilized. So about 15 years later, in fact, exactly 15 years later, in 1942, the U.S. Supreme Court turned on that in a case called Skinner v. Oklahoma. It didn't explicitly overrule Buck v. Bell, but everybody understood that that was the tacit holding of Skinner v. Oklahoma. Does anybody know what happened during those 15 years between 1927 and 1942 that got people thinking about eugenic sterilization in a somewhat different light? Yeah, there was some ugliness in Europe, and believe it or not, the Nazis got their eugenic sterilization laws from us. They got them from us. And because we had done such a good job pioneering in the area, that they borrowed them for us and obviously put them into even greater effect. And so I think this focused some people's attention. I'll give you one other example of a right that kind of moved from, well, I think it's moved from meaningless to meaningful. My wife is here in the audience. Some of her relatives, she's half Japanese and half Irish. Some of her relatives died in the camps in World War II. As some of you probably know, during World War II, we put Japanese Americans in concentration camps here in the United States. They weren't a very healthy place to be. There was a lot of tuberculosis and other diseases, and some people died. Interestingly enough, some of those people died in those camps while their relatives, including some of my wife's relatives, were fighting in Europe in the 442nd Combat Regiment. It was the most decorated regiment in all of World War II. They fought with great valor and distinction while many of their relatives were back home dying in camps. When that went up to the U.S. Supreme Court in, I believe it was 1943, in the Korematsu case, the U.S. Supreme Court said, that's fine, wartime measure, none of our business. And I think that would not be permitted, again, at least not with American citizens. So I think that right has moved from meaningless to meaningful. Those are the only two that really come to my mind. The trend has been very much the other way. The trend has been in favor of abdication under sort of ritual pledges of restraint, modesty, and deference. And if you ever watch another Supreme Court hearing, just if you want to play a really fun drinking game, just line up a bunch of shots, and every time a Supreme Court nominee pledges to be restrained, modest, or deferential, just take a shot. You'll be drunk in the first 10 minutes. Any other questions? I don't know what made me think of that.
I wonder what you think would happen if the courts had pushed back on some of these examples, because I know Hamilton referred to the judicial branch as the weakest branch, and of course you remember the switch in time to save 9, FDR's court packing schemes. It does seem like the other political branches exert quite substantial influence, even in maybe a kind of a hint. If you do go this path, then we're going to adversely affect the judicial institution. Yep. You think the judicial institution has taken cues from that and kind of kowtowed to what the other branches have liked?
Well, I do think public perception influences sometimes what I call sort of the zone of the possible. There are some issues, that it's just clear the Supreme Court's just not going to rule in your favor. I was one of the lawyers in the Heller gun case. I don't think the Supreme Court would have done what they did. As you probably know, they struck down D.C.'s gun ban in 2008 by a 5-4 decision. I don't think it would have been a good idea to bring that case in the 1970s, the 1980s, maybe not even the 1990s. But enough changed, I think, both by way of public perception and academic scholarship at the time was right, to bring that case. So I do think that public perception and to a certain extent the interplay of fundamentally political dynamics between the court and the other branches can matter to a certain extent. I will say this, though. I think that I do not agree with people who say that the Supreme Court can never get out in front of public opinion or political will, for example. If you ask someone, just the average person in the street, to tell you the greatest Supreme Court decision in history, I would bet that more often than not you'll hear Brown v. Board of Education, which is where the Supreme Court got pretty well out ahead, at least ahead of a certain region of the country, in terms of its willingness to stop the official segregation of the races. And people look back on that and think that that was really a shining moment for the Supreme Court and something that we really admire about the Supreme Court, and stands as a really a stark contrast to the Korematsu case that I described earlier, where the Supreme Court checked out and allowed American citizens to be put into concentration camps. There is a tremendous contrast between those decisions. And even though the Supreme Court was well out ahead of political will and somewhat out ahead of popular will in Brown v. Board of Education, it was arguably its greatest moment in history. So I take some heart from that. Anybody else? Other questions? Yeah.
Chad from the Arcata Center. You mentioned the importance of popular will, and I think one of the things you all do pretty well is combine that with your litigation work on the occupational licensure laws in particular. If you had 2, 3, 4 IJs, what are issue areas like occupational licensure that you feel the public messaging is very feasible, or the public will just needs a little extra push in one direction or the other to combine with litigation? So what are the other opportunities that you would love to pursue if you had 7 Clark Neilys?
What a disturbing image. Wow, let me think about that. Well, okay. I think one of the most disgraceful, by the way, I hope you, I'm a total patriot. I love America. I have traveled all over the world. I was a Russian major. I was in the Soviet Union. I know what the rest of the world looks like. So don't get me wrong. I am a huge patriot. I have a burning love for this country and for the Constitution. But there's a lot that needs fixing. And I think one of the most disgraceful things about this country is that we have the highest incarceration rate of any country in the world. Any country in the world. And that is not because Americans are more disposed to being criminals. That's because we have ridiculous laws that get enacted for ridiculous purposes and then are allowed to stay on the books, even though, in my judgment, they are blatantly unconstitutional. Growing a plant in your backyard and giving it to a neighbor is a blatantly unconstitutional law, no matter what that plant is. But we have a court system that is checked out, not really enforcing the Constitution in any meaningful way. I think it's a disgrace. I think it's a disgrace the number of people we put in jail for nonviolent crimes like drug possession, specifically marijuana possession, things like that. And I feel a little ashamed every time I think about that issue. So if I had some extra capacity, I'd work on changing that. I'll give you another example of something I would challenge that's somewhat connected. I don't know if anybody's heard of or read Radley Balco's book, The Rise of the Warrior Cop, about the militarization of the American police forces. I see some nodding heads, so that's reassuring. Well, look, if you go into somebody's house and you throw a flashbang grenade into their living room and then you storm into their child's room and pull a little kid out of bed and throw that kid face down on the floor and put a gun to the back of that kid's head, you should never work again. You should be financially ruined. The only question would be whether you should go to jail after everything that you own is taken away from you and given to that family by way of compensation. You know why that doesn't happen in this country? The reason that doesn't happen in this country is something called qualified immunity. A qualified immunity is a legal doctrine that the courts invented out of whole cloth in order to prevent people from suing police officers and other public officials who engage in that kind of conduct. If a regular private person came into your house and did that, you would certainly be able to sue them, and they would certainly lose everything they have to you. But if someone with a badge does it, then they're completely, well, not completely, but they're almost completely shielded, because the only way you can get around qualified immunity is if the public official that you're suing has violated a clearly established constitutional right. And I'm here to tell you that when you're talking about the Fourth Amendment, there's really no such thing anymore as a clearly established Fourth Amendment constitutional right, because it's just a giant piece of Swiss cheese. And so you're never going to successfully sue, or you're almost never going to successfully sue somebody who engages in that kind of behavior. And it vexes me, as you can probably tell, that this qualified immunity that renders these people who do these terrible things wholly unaccountable, that wasn't even imposed on us by a legislature. That was invented out of whole cloth by the theoretically neutral third branch of government, whose job it is to serve as a check against the other branches. They made that up and just handed that on a silver platter to the other branches. I just can't get my mind around that. So if I had, again, some excess capacity, I would probably devote all of my energy to getting rid of qualified immunity. And then I'll just add one more thing, because this is a personal thing with me. And I get a little choked up when I think about this. It turns out that police shoot a lot of dogs in the line of duty. And They just seem to be really terrified. Even dogs like down to the size of little Chihuahuas and Schnauzers are apparently a lethal threat to these heavily armored, equipment-bearing cops. And so there's actually a documentary that somebody's got on Kickstarter called Puppycide, and they're essentially making a documentary. So, for me, that just puts it in particularly poignant terms. And again, I don't see any reason why we should have to do that to our fellow citizens. I don't see anything that's so compelling, about shutting down somebody who's, again, selling a plant out of their house that they need to be treated that way. So those are a few issues I guess I'd be working on if I weren't keeping the man down on the economic front. Anybody else? All right, well, listen, thank you very much for having me. I really appreciate the opportunity to talk to you. Thank you. The opportunity to talk to you. Thank you.